Counsel. Hey, please the court. My name is Maria Ruhtenberg. I represent Mr. Doolin in this appeal. I'd like to start with a quote. There was nothing more convincing to a jury than a live human being who takes the stand, points a finger at the defendant, and says, "That's him. That's the one." That's what happened in this case with zero pre-trial identification or much of a description, where the witness spent approximately 20 seconds in his life with a man in his car with a gun pointed at his chest, was unable thereafter to give any description of him, said he couldn't describe him because he was focused on the gun. He just said it was a black man. No lineup was given to him. Nothing was done. He was from out of state. He left the police station the night of the incident, went home. 2 years later, he shows up to court as a witness, and really the only witness who identifies my client, the defendant, as the man pointing the gun at him and positively ID'd him at the request of the prosecutor under questioning that was worded in such a way that presumed that the perpetrator was in fact in the room. In 2005, this court, in Folkerts, stated that the seating of a defendant next to his or her attorney at a deposition of an eyewitness is clearly suggestive as to be impermissible. Surely that's not any different to have the same identification procedure.
You know, after Folkerts, the U.S. Supreme Court in Perry in an 8-1 decision sort of clarified that a lot of the due process grounds for challenging eyewitness identifications are really focused on police misconduct to deter and encourage better lineups, photo arrays. And a number of courts, including the Colorado Supreme Court majority, have said that due process challenge doesn't work. The trial judge doesn't have to pre-screen. Should we follow Perry here?
I would say no. The Perry court in Manson, in a footnote 9, specifically even said that the reliability analysis applies to in-court identifications. The court in Manson stated that reliability is the linchpin of pretrial identifications, or the reliability of identifications. Excuse me.
You need to get a glass of water? You may, yeah.
Coughing all morning, so I apologize for that.
Take your time.
So, the due process analysis, or the protections that the court has in a jury trial, does not magically transform an otherwise unduly suggestive show-up, which is what it is here, into a reliable identification. It really is no different from a deposition or from other pretrial.
Here, I think it is different in this respect. Tell me if I'm wrong, Ms. Ruhtenberg. Any pretrial identification, if you admit it at trial, in a sense it's hearsay because it's something that happened out of court being offered for the truth of the matter asserted. It happens in court, it's not hearsay, it's live. The person who's making the identification is there. All the improbabilities that you say exist with respect to this identification can be, and I think largely were, fully explored by defense counsel. I mean, witnesses in the courtroom get to testify to all kinds of things that you or I might think are improbable, unlikely, implausible, and we rely on the trial to sort those things out, and the jury, because the jury is there watching the whole thing. Why is identification so special that it needs to be separated out from all other forms of evidence?
Identification is so special because it's so powerful. It's one of the most convincing forms of testimony to a jury, and it is also one of the most unreliable. it is responsible for many, many false convictions. The studies, the science that has been developed since Manson has proven that our conventional thinking and the Biggers analysis and all of those factors that we have previously looked at on a pretrial situation to see if there was an unduly suggestive lineup have been proven to really not be the case. The science has shown that in order to have a truly reliable identification, it has to be a double-blind procedure where witnesses are told that the defendant may not even be in the lineup, and all of these other things, that protections. The jury is not somehow able to, the jury is going to have the same misconceptions that everybody else did before the science proved us wrong. So there is nothing to say that a jury can assess the credibility of the witness, but the jury is unable to, without the specific knowledge, to really assess the reliability of a witness testifying. And many of these witnesses are not lying. They're not trying to finger the wrong person on purpose. They honestly believe that that is the person because they're sitting at counsel table. And in this case, having never described or seen the person before.
Isn't that the job of a defense counsel, to maybe get an expert to pull those things out and start having that be a part of the case, such as Justice Mansfield talked about?
I think an expert, in any case, in any specific situation, whether it be a pretrial or during trial identification, expert testimony can be helpful. If we're going to go to the rule, basically it's going to be where the defense counsel is going to have to call an expert witness. It would be required to and be ineffective if not.
In your appellate briefing or application for further review, did you argue that the defense counsel was ineffective for reasons that included he didn't ask for an expert?
We did not.
Okay. Is that in play here then today?
I'm sorry?
So is that argument, is that issue in play?
No, not that portion. We argued in our brief that counsel was ineffective for failing to object to the procedure, to the identification itself.
And how would that have played out if they had objected? Was the goal to exclude the identification altogether?
Yes, and if you look at where Massachusetts and Connecticut have gone with this issue, and I think they do both those cases do a nice job of the analysis of why that in-court identification is so suggestive and so damaging and to be impermissible. And both of the courts have basically disallowed those in-court identifications unless it's a situation where the defendant knows they know each other from a prior. The identity is not the fighting issue in the case.
Or some independent source, actually.
Right.
They leave the door open, but the in-court identification is suppressed.
Yes.
But what the Court of Appeals found the record inadequate to reach the ineffective assistance of counsel, preserved them for PCR. Could there have been a strategic decision made here? Maybe if he objects, then it results in a photo array and a lineup, and if the victim identified Doolin, then you're worse off. Should we let this go to PCR?
Well, that's a lot of assumptions, and I think given the strategy, both the strategy of the attorney at the time obviously was to attack the credibility of that witness, and did cross-examine on that, and the fact that this was the only witness who was able to identify the defendant as a person in that car. There was another witness who was with him, a friend, wasn't able to give an identification. So the state's case rested entirely on that identification.
What about the security guard? He identified Doolin as there with a weapon?
Well, there were more than one people at the club that night with a weapon, and he was arrested with a weapon, and so that's a separate issue that we're not necessarily disputing that Mr. Doolin wasn't at the club, but there was the identification of him for the crime against this eyewitness. This eyewitness was the state's case, And if you suppress that identification, it goes away. So I don't conceivably see a strategic reason for counsel to not try to do that.
What about counsel's failure to request the ISBA jury instruction 200.45 on eyewitness identification? Could there have been a strategic reason for that, in that some of the statements in that instruction might have hurt more than helped, as we concluded in State v. Shorter?
In reviewing the instruction, I mean, the instruction kind of tracks the Biggers factors, and it's, you know, given the state of the science, it's not a great instruction, but it would have been an instruction from the court on the law about the weaknesses of eyewitness identification, and back up his arguments about the weakness of this identification procedure in court and the witness's testimony.
How was Mr. Doolin prejudiced by the failure to give that instruction? How can we conclude prejudice has been established here? Because
the evidence otherwise was so, I mean, it's not overwhelming evidence in here, in this case, that he was the guy in the car. Like I said, the case sort of turns on that identification, and if there's an instruction that sort of gives credibility and backs up the arguments of counsel, I think it's you know, I mean, it really casts doubt on the validity of that conviction. You're not arguing in your briefing that counsel should have requested the Henderson instruction or one of these more beefed up instructions, right? No, we just, you know, we're just addressing the instruction that's already there, the uniform instruction. The very least counsel could have done would have been to have that instruction. Should we abandon the Biggers factors for in-court trial identifications? Yes. I think that the Biggers, like I said, back in 30 years ago when those factors came out, they really weren't necessarily backed up by science. There was the science just beginning to be researched on eyewitness identification, and there's been so much that has happened since then that shows that even without that, the Biggers factors sort of swallow the rule. Science shows you can't really rehabilitate overly suggestive identification. Time lapse, in this case, I think is a big issue, where 2 years goes by where the science shows that after 2 hours it might as well be a coin flip if a person can identify the suspect. So there are a lot of problems with those Biggers factors. They're not based in science. A lot of other states have abandoned those factors, and this court should also abandon those. What's the limiting principle, though? Are we going to exclude any first-time in-court identification by a crime victim just if some time has gone beyond and they didn't make an identification right away? I think yes, and I think that's what the Massachusetts and the Connecticut court, I can't remember exactly which one, said that an in-court identification, because of that time lapse, is never going to constitute what they cause good cause for allowing the in-court identification. It just becomes, it's not only the time, it's the show up, it's all the other factors. It's the sitting at counsel table. It's the pressure that witness has sitting in front of the jury with the judge and a prosecutor asking, can you identify this person in the courtroom for us today? Are you assuming that's only stranger identification? Well, yeah. I mean, because I'm saying if my neighbor did something and I haven't seen him since then, I was never asked, but I know darn well who he is. Are you saying if I, for the first time, would reveal that in trial, that would be excluded? No. So stranger identification is what you're talking about? Like I said, the court, when identity is not an issue, the courts have allowed that the two courts have excluded first-time in-court identifications, make an exception for a situation like that when the identity of the defendant is... Well, I was assuming that identity was an issue, that maybe there's a denial that it was him,
this person's certain that it was, maybe not a next door neighbor, but knows him well. But my point is, don't we have to start kind of tearing it apart like an onion peel? And at what level do you say it would be excluded outright? And at what times would you allow it to be in? Does there have to be some relationship?
I think that there could be, like the other courts have done, they've had a hearing on it and had the judge make a determination. I think one of the courts will allow the out-of-court identification procedure, and the other one states that there has to be good cause for the identification. So the judge would make that screening determination or have a hearing outside the presence of the jury to determine if that situation exists, that it would not be or not be unreliable. The problem with the case that we have is that we don't have that. In his testimony at trial, the eyewitness stated that he'd never seen this person before. I see my time is up. I'm sorry.
You may sum up. Thank you, Counsel. Mr. Mullins.
Good morning. May it please the Court. I think we need to recall the context in which we find ourselves, and this is an ineffective assistance of counsel claim. So excluding all first-time in-court identifications really outruns the established law.
Oh, don't need to do that, but this one has a couple features. First, at the time of the crime, he couldn't give a description except to say African American. I mean, nothing about hairstyle, nothing about clothing, nothing about jewelry, nothing about any characteristics. In fact, you couldn't have done a lineup or photo array because there was no description other than say African American. That was contemporaneous with the crime. Then 2 years later, he comes up with in-court identification. Even bigger says that a delay of 7 months in identification is a serious negative problem. Even the Supreme Court's least aggressive approach here suggests that a delay of a period of time is problematic. Here we have a 2-year delay. We have suggestive questioning from counsel, and contemporaneously, when memory is still better, we have nothing. Under those state of facts, and it's a stranger identification, by the way. Under those state of facts, how can this identification be sufficiently reliable to survive a due process analysis? It's just so unreliable, even using Bigger's factors, that it ought to be tossed.
And as the abundant authority shows, that's grist for the mill. You've essentially laid out an effective cross-examination, and at the trial, defendant has the benefit of counsel, compulsory process, could have called experts if he'd chosen or believed that it was appropriate, could have, as Justice Ginsburg for the court in Perry acknowledged, could have asked for an extensive eyewitness identification instruction.
Yeah, but we had Folkerts out there in 2005, and Folkerts is has a red nose for this case. I mean, it's a deposition context, but it has all the discussion of eyewitness science, or partly discussion of the eyewitness science. Says to show up in the deposition. You know what the case says, of course. To show up in the deposition context would be impermissibly suggestive. So, how do we have a lawyer now, 15 years after, or maybe not quite 15, 10 years after Folkerts? We have this, what amounts to in-court show-up, and he does nothing. Isn't that problematic?
Well, and as long as we're going to talk about the vagaries of memory, I can tell you I remember that case vividly, Folkerts. 3 of the members of the bench, including Your Honor, actually physically got up out of their chairs to talk to me about it in forceful terms. The problem with Folkerts is that the court had an opportunity to correct an unreliable identification before it propagated, which is really the point of the Manson versus Braithwaite, Niles versus Biggers, and as Justice Ginsburg had illuminated, the problem really with pre-indictment identifications is that they lack the opportunity for all of the tools that are available to a person at trial. Due process doesn't exclude unreliable evidence. It confers tools upon a person to expose to the jury so the jury can make a decision for itself. So Folkerts had an opportunity to say, before this problem begins to propagate, we can address it at that point. And so that's why they had established the procedure that it did. And so now, and again, consistent with the dominant authority, which is what we can expect counsel to know, and we think counsel must know, what would be the survey of the land? As far as in-court identifications go, we're no longer talking about either pre-indictment identifications or simply pre-trial identifications altogether. At that point, what counsel would have known is there were no federal courts that would have excluded a person, or rather called a suggestive identification, so per se suggestive that it must be excluded. They would either...
We got Brown out of the Second Circuit in 1983. Brown seems to suggest that and rather than have an in-court show-up, there has to be some kind of out-of-court photo array or some kind of presentation.
Which, incidentally, may be something that this defendant might not have wanted to hazard. Now, I can assume that in any given circumstance, depending on the courageousness of the attorney or the defendant, they may say, yeah, sure, let's go ahead and have another identification. But what if the witness is successfully able to pick him out in that other circumstance? Now you have two, and you have lost the ability to argue in front of the jury that this was effectively a one-person show-up. And by the way, one-person show-ups aren't necessarily suggestive. The facts of this case indicate that perhaps they are not, because we know there's at least one witness here who declined to identify the defendant at the table.
We said in State versus Webb in 1994, we have stated that even where a pretrial identification is obtained by an illegal procedure, the same witness may nevertheless identify a defendant at trial if such identification has an independent origin. So it seems to me to follow from that if there's no pretrial identification, Webb allows in-court identification. Is that what you're saying?
That's my understanding, and I believe that would be...
So 100 years later or 40 years later, you could come in and make the in-court identification?
I'm sorry, your question there is...
The question is, if the passage of time is more than 2 years, but is 15 years, and the individual could not make a contemporaneous identification, that stale identification after the decay of memory would be admissible? Really?
Absolutely, because at some point we have to place some faith in juries. And at this point now, I think we've seen enough of juries to know, and this court doesn't often see acquittals, but we have to at some point trust that jurors, particularly when they're exposed to some of the science, if they were...
Of course, they weren't exposed to the science, nor were they even instructed on issues of eyewitness identification. Doesn't that give you kind of a problem? The jury was presented with this unreliable evidence and got no instruction on how to handle it even. The science shows that jurors' presumptions about eyewitness identification, it's a Cadillac, it's a gold standard, et cetera, it just isn't right.
Of course. So the way I view it is, and this is, of course, a hackneyed way, but I looked at that eyewitness instruction as a prosecutor and thought, okay, I'd give that, which necessarily means any other defense attorney is probably going to could take the other view, all right? Likewise, a defense attorney, sometimes you will get a case, and let me pull back to this one instead of the 40-year-old identification, and say, sometimes a case is as good as it's going to get at this point. And so to ask for an eyewitness identification instruction hazards some perils. Now, some attorneys might choose that might choose, and in fact, this court could encourage attorneys or district courts to offer this instruction. We make no claim that it's improper to offer this kind of instruction. Perry versus New Hampshire, in fact, endorses it. The problem, though, as is in Shorter's, we're in the situation where there's at least a debatable question to it. And Your Honor might choose, if you were practicing and trying this case, to say, absolutely, I would totally do this. Darrel, maybe he would not. But that, of course, from Ondeag In other cases, or Caldwell, how we would individually surmise the benefits of a particular instruction is not the standard.
Well, should we send this case to PCR and let the defense counsel explain? Maybe he had a strategy for not requesting that instruction, thought it might hurt more than it helps.
I am most comfortable with the notion that this record is inadequate to find counsel ineffective. I would, of course, leave open the door for a subsequent post-conviction relief action. On the closer question of the jury instruction, I think the legal question of exclusion of all first-time or even this particular first-time in-court eyewitness identification is a far easier matter to resolve.
Really, and when Biggers says 7 months is a serious negative factor, I mean, even Biggers, as they say, not now, admittedly, Biggers it turned out the defendant didn't prevail, but all the science says memory decays, never improves. He didn't know contemporaneously, couldn't describe him. Then all of a sudden he comes in 2 years later. Isn't that a fairly compelling case of unreliable identification?
And Your Honor will occasionally ask me questions, and by the end of the question I've forgotten either where it started or where I need to go. And that emphasizes your point to the extent that it's something that we understand now and we expect jurors to understand and can deal with. So Biggers and Braithwaite are pre-indictment and pre-trial cases. Perry versus New Hampshire makes it clear, as do all of the other cases except Connecticut and Massachusetts, that in court is different. Once you're in court, you have an opportunity to explain to the jury the reasons why the passage of 40 years, for example, is so long that this identification simply cannot be credited.
Sir, I have a question for you. The defense counsel made quite a bit of conversation about the fact that ID was your case. That's it. Could you respond to that?
Well, I can say that identification was certainly the defense and it was an issue. But if you consider the progression of the events at the time, we know from the surveillance video that the defendant and Mankovic, the driver's friend, are going from the entrance to the strip club to their car, or to Berkovic's car. The perpetrator gets out of the car as the police are arriving, and Officer Mullenbrook made clear that the lights of his car were visible to the east parking lot as he pulled in. So the person is getting out of the car as the police are arriving, and Mullenbrook shortly thereafter sees the defendant hiding behind a vehicle and hears the clink of the gun and takes him into custody. So there's that tight timing that narrows the possible range of suspects. And by the way, we can positively exclude the man in the white hoodie with the other gun. He's not seen going towards the car. So unless there's the possibility that everybody going to these strip clubs is armed, which is yet another reason to maybe forego going
Wasn't there evidence that he looked very different from the defendant? I think that was the bouncer said that.
The bouncer, and that does actually illuminate another issue. The fact is that the bouncer was pretty clear and could identify the Doolin by what he was wearing at the time. So the sequence of things, including also the rudimentary description of the gun as a black semi-automatic, does tighten things down enough that for purposes of ineffective assistance of counsel, the court doesn't need to have a concern that there's a reasonable likelihood of a different result.
Counsel, let me just quickly return to the in-court identification in the absence of a jury instruction about eyewitness identification. Isn't that a problem when without the eyewitness identification and jury instruction that the jury's left with those instructions that say, use your good judgment, use your common sense when you're trying to decide these questions? Aren't we just leading the jury into an area that all of the science says is so wrong when we're telling them to use their their judgment and common sense instead of actually identifying the factors that need to be considered when you're talking about eyewitness identification?
Well, I can endorse the value of an eyewitness identification instruction. But here, particularly given that we had one witness who was willing to, under the glare of the lights, say, no, I'm not going to identify the defendant. But then we have another witness who, in fact, of the three others who did identify him, there's the victim who identifies him. There's also a rather, for my money, a rather effective cross-examination illuminating just those facts that you had posed. There was argument on the point. I don't know that it was a foregone conclusion that the jury was going to convict based on that particular narrow constellation of facts, bearing in mind also that there were other instructions, and it wasn't so much of a freewheeling kind of consideration that these instructions left the jury to perform. The instructions talked about the vagaries of memory and bias, the prior inconsistent statements, things of that nature. It doesn't make this case, with the exception of the passage of time, doesn't make this case appreciably different than State versus Shorter, at least as far as the strategic decision of whether to ask for this instruction. Would another attorney have done something differently? Perhaps. We don't know. We don't know what advice this attorney gave to his client. We don't know what directions this client gave to his counsel. For those reasons, we respectfully ask that the judgment be affirmed and the decision of the Court of Appeals be affirmed as well. Thank you.
Mr. Mullins, thank you as well. Ms. Ruhtenberg may present your rebuttal.
Thank you. Prior to Stovall, courts treated the eyewitness identification with reliability, as we talked about, as a province of the jury. When the United States Supreme Court decided Stovall, they established that there are some eyewitness identifications that are so suggestive that it violates due process. And we don't trust those identifications to be presented to the jury. That started the line of cases that have developed into the Manson and Biggers, et cetera.
Shouldn't we follow Perry?
Well, Perry is distinguishable. First of all, Perry says that Manson's primary objective was police deterrence. And I respectfully disagree with that. If you read Manson, reliability was what they were concerned about, not simply deterring police from misconduct. Perry also mischaracterizes that as well, in the sense that even if in a deterrent situation, what has developed was not factors just to deter misconduct, but to deter or to prevent police from informing the defense or the witness without meaning to.
Perry involved an independent actor making an independent identification. The state put the witness on the stand, and the state asked the questions. And it seems fair, even under Perry, to charge the state with whatever due process violations are present. There's not a third-party actor making identification.
Right.
But in Perry, the witness identified Mr. Perry, who's standing next to a police officer. It's essentially a show-up, right?
Right. And I think that that's a distinction that we don't have in this case. We have state action here. Prosecutors are part of the state. They're, doing the same role in this kind of in-court identification as a police officer would do prior to in a lineup, or as in Folkerts when the prosecutor did the same thing in a deposition. So we do have state action. This is not a situation where the witness, came to trial and said, "Yeah, that's the guy."
I'm still uncomfortable whether the record is adequate to decide whether counsel should have objected to the in-court identification if that might have led to some kind of photo array or a lineup that maybe defense counsel chose to not take that risk. Is the record adequate or not?
I believe that it is. Obviously, if the court feels, otherwise, then yeah, preserve it for PCR.
Of course, the question is whether you can unring the bell, right? You had the in-court identification that arguably was improper. Now, I understand there's some suggestion that it was fine, but how do you, the cases that require pretrial identification usually happens pretrial. That's one of the points that's been made here. So how do you unring the bell when somebody comes into court, sees somebody sit in the counsel table, makes the identification? Indeed, the eyewitness science suggests that you can't. I mean, it's tainted.
It's tainted, and the more suggestive, if you make an identification on a suggestive identification, it exponentially confirms that identification, and it becomes even more wrong, even though the witness is more.
What about the argument that Mr. Mullins seems to be making that under established Iowa law, and I read Webb, that there is no basis to object to an in-court identification the same way there is to a pretrial identification? I mean, is it ineffective assistance for counsel to fail to argue for a change in our established law at trial?
Well, I think counsel should have been aware. I mean, the science is being developed over 30 years. The Massachusetts and Connecticut cases had been decided prior to this case going to trial. The in-court identification procedure is what our argument is no different from those pretrial. And so shouldn't the defendant be granted the same protections from an unnecessarily suggestive in-court identification if it's a violation of due process for the prosecutor to do it in a deposition or for the police to do it at the police station? Why is it not a violation of the due process to have the same unnecessary suggestive identification at court? In fact, it's even worse because of all of the pressure on the witness at court. And for those reasons, we ask that the court reverse the convictions. Thank you.
Ms. Ruhtenberg, thank you. Mr. Mullins, thank you again. The case of State versus Doolin is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.